All right, so we go to the third part. Using the law to frame my argument. Like I said before, I've done closings that are 3 hours long. How is it that you figure out what you say when? Trust me, if I do 3 hours of a ramble, that ain't making anyone happy. That's going to be passing out double shots and faster than they fell asleep during jury instructions. It has to be organized and framed in a certain way. And I use the elements. It's not unlike this PowerPoint presentation. If I have 3 things I want to talk about, and I'm going to take up your time for a half an hour, I know that I'm hitting the points and I'm thinking about what I want to say. The same thing I would do with my elements, right? And I'm going to use the law, particularly the elements, or key instructions like circumstantial evidence, like credibility of witnesses. I'm going to use those things to launch into the next important part of my closing that I want to talk about. So I don't really need to remember line for line, and people that are in my litigation center and on our mock trial competitions know we don't do any memorizing, and we're not reading out anything. We are arguing from points of law. So what I want to do is I'll take the element and argue from it. Argue about what witness. Let's look at how you would actually frame an argument. So I take the elements. I take other key jury instructions. I narrow the dispute for the jury. I will submit to you that every time that you take elements out there and you have 4 of them, you have 3 of them, the fight and the reason you're at trial is not all of them. It's not all 3. It's not all 4. And here's a flash forward, guess what? When you are filling out those elements on your exams and you're eye-racking and doing your thing, right? I guarantee not all those are at issue either. You are going to list off elements, and then 1 or maybe 2 is going to be what the whole fight is about. 1, maybe 2 is going to be what the whole essay is about. You need to narrow that dispute and explain what's really at issue for your jury, right? They want to know, right? They are being put in a chair to do a job that they don't ordinarily do. They love some beacon of truth at this trial to tell them how to carry out that duty that they're hanging on to for that week or that month. They want help. Be the one to help them, right? If you're going to have the 4 elements up there or the 3 elements up there, you can say, look at the first one. The first one is not an issue between us, the prosecution, and them, the defense. We've actually stipulated to it. Stipulation is just a fancy way that lawyers agree to something. And we agreed to this first element. We also heard a jury instruction. It was in that long packet. You might not have heard it. But it said, if we stipulate to anything, you should take it as conclusively proven. So as it relates to this first element, we've stipulated and agreed, and you're to take it as conclusively proven. I think we can all move on to something that's actually at issue. And I'll present it like that. What is that jury doing with that one element? They're saying, got it, mental check mark, let's move on. Let's narrow the dispute. What is this fight about? What has this circus of direct and cross-examinations and different witnesses and stipulations and objections and responses and lunch breaks, what has this all been about? I'm about to explain to you what it's all been about. I'm going to narrow the dispute for you. Second one, after I narrow the dispute, I need to figure out how I'm going to frame my argument. You will see, if you go out there, right, and just go into court and start watching trial, you will see people that take it up chronologically. Right? On day 1, we heard from this witness and that witness. Right? The same crappy presentation that came out in trial, the same disorder that came out as a product of trial, you're going to recap in that order. Don't do that. You see others that just go chronologically. On this day, this happened. Then it came to the next day. Right? And they go novelist. Sounds like a book on tape. Right? You know what happens with books on tape? Unfortunately, even when some people are driving, people fall asleep. So don't do that. It doesn't need to be straight out chronological. It doesn't need to be straight out the way that the order of trial went. Instead, frame your argument by what suits your needs. If you need them to go in a room, in a jury deliberation room, and get a jury verdict form that says, as to negligence, right? As to negligence, do you find that the plaintiff was, or the defendant was negligent? You need them to check that block. So what you need to do to make it easy on these people that are sitting in this chair for a week is explain to them that in order to check that block, that means the following 5 things. It means duty, breach, causation, so on and so forth. It means those things. I'm going to explain to you what it is, and I'm going to narrow the dispute to tell you, you know what? There's no doubt there was a duty. There's no doubt there was a breach here. This issue is causation. I'm going to narrow it down and frame it out. And then when I get to causation, when I get to that one element that I've now isolated for you is where the dispute lies, I'm going to figure out all the things that happen in trial, my way, my words, my evidence, and I'm going to organize them for you under that element. I'm going to help you out in jury deliberation room as a juror to sit there in that free-flowing, crappy conversation that happens between jurors when they deliberate to say, here's why it's causation. Here's why there was causation here. Heard from this witness said this, another witness said that, this document said this, that had a stipulation, there was judicial notice. Whatever the form of the evidence that came up at trial, I organize it for you. And I hand it to you as a juror to be armed in that discussion in case anyone in the room dare say that there was no causation. Let that person raise their argument with the benefit of my opponent's ammo, and I'm going to give you the ammo to find the right way as it relates to causation and check the block the right way as it relates to was the defendant negligent. Frame your argument that way, arm your argument that way. So let's look at this. If you have the burden, it kind of gets easy because you can always use the elements. You can always say elements 1, 2, 3. I narrow it down by saying 1's not at issue or 1 and 3 are not at issue. And let's focus on 2. If I took all the criminal cases that we do, I guarantee we're always narrowing down to that intent element. Sometimes it's not a matter of whether someone did something or not. It's certainly not a matter of whether we're in the right jurisdiction. It's a matter of whether they did it knowingly or intentionally or recklessly or all the other foolish adverbs that lawmakers come up with when they write them into statutes, right? So I'm usually narrowing down or organizing my argument by the elements. Sometimes all that matters is who did it. So I'm going to look to the factors that we can consider for identity. Sometimes jurisdiction might be the issue, right? And I will be arguing and narrowing it down to that key instruction that falls outside the elements. It's for me, as the composer who put this case together, who decided which witnesses, which evidence, in which order, it's for me to now explain to you at the end of the day, after I put on that whole show, and my opponent tried to disorganize it and pull it apart and confuse you, it's for me to put it all back together and explain. And if you think about it, it's the only way that our system actually works. How do we take 12 randoms from the BART? How do we take 12 randoms from the DMV, put them in a box for a day, a week, a month, more months, and somehow expect them to digest the law, which you guys go to school for years to learn? To somehow organize the facts when they come up in this complicated way. We are comfortable with that process. That process has been the way it's worked for a long time. And you know why it works? Because trial lawyers must do the explaining, must do the framing, and being a trial lawyer and who's the better trial lawyer absolutely matters. We wouldn't be spending